In the back of the room.
We're right here, honey.
Get in line.
What? You get brattier every time I see you.
Yes, sir. I just want to run over those questions again real quickly.
I need. Gee.
Oh, yeah, this is. The first one was.
What are you looking for, honey?
I'm looking for those folders, those red folders that I put together.
Aren't they in that box?
No.
Simple. I'm sorry, that's not what I wanted.
We're going to start on time. Ladies and gentlemen, I have 9:45. Politics runs on time, so we're going to start on time. My name is Eric Kerr. I'm the chairman of the 1st Congressional District, Republican Party of Virginia. Our speakers will be back in just a minute, but let me take this time to let you know how this format is going to work. The topic is the Convention of the States debate, and we're going to start out with a 9-minute statement from each side. And then we're going to have questions. Each side will have a minute to ask a question of the other side, and we're going to alternate that back and forth for a total of 20 minutes. And then we're going to have audience questions. When the gentlemen are speaking, you'll have Mike Farris at this podium. You'll have Richard Fry at this podium. When we get to the point where we're going to have questions from the audience, both of our speakers will shift this way. And we'll have a queue of people who want to have questions right here. Then when you have your question, you'll speak. You'll come up to this mic to state your questions. And I believe this is being recorded. So if you're not comfortable with your question being recorded, ask someone else to have it done for you. But one thing I will ask and I will insist on is when you come up for a mic, you are asking a question. I don't need 3 or 4 other participants in the debate with any question that starts out, isn't it true that? I'm going to be very dubious of. And if it becomes a soliloquy, I'm going to ask you to step away from the mic. So I'd ask that your questions be honest questions, and the gentleman will have a chance to answer those questions. Okay? So that's the way we'll handle that. So with that said, we have from the Convention of the States Project, Mr. Mike Farris. We have from the Patriot Coalition, Mr. Richard Fry. And like I said, politics runs on time, so we're going to begin. The general format is Mr. Farris will speak, and Mr. Fry will respond. When you have a question, we will hear the question, and then both debaters will have 1 minute to respond to the question. If you have a particular one you want to hear from first, state so in your question. Otherwise, we'll just stay with a normal flow with Farris and Fry in that order, answering the question. So, with that said, we have a timekeeper here who's going to keep us honest on the time. And when the time is up, I'd like you to just raise your hand so everyone knows the time is up in the room. And I'm sure the speaker will comply, whoever it is, and wrap up that statement. Okay. So with that said, I'll turn. Both the speakers are going to stand up out of respect for the audience for the whole debate, and we'll start off with Mr. Farris.
Good morning. Thank you for coming. I want to give just a little bit more background on my professional history and my experience, because an important component of this debate is who do you believe? Who has the credentials? Who has the background? Who has the understanding of the Constitution of the United States to justify you accepting your position? We're both lawyers, I practice constitutional law, which means I go to court and defend people against the government, arguing that their constitutional rights have been violated by the government. I've done that for almost 40 years now. Since 1976 is when I first became a lawyer. I have litigated constitutional cases in 13 state appellate courts, in the United States Supreme Court, in 8 circuit courts of appeal. I've written textbooks on constitutional law. I teach constitutional law. I've written law review articles on constitutional law. I am a constitutional litigator. I'm a constitutional lawyer. A person who is a lawyer, who calls himself a constitutional lawyer, needs to practice constitutional law. Doing trip and fall cases at Walmart, at banks, cases involving leaky pipes, which are the kind of cases Mr. Fry has done, are not constitutional litigation. It'd be like a doctor who took classes at medical school on the heart, calling themselves a cardiac surgeon and never litigating or never performing cardiac surgery. And so I am a constitutional lawyer. In fact, I've litigated Article V case that was litigated at the district court level, was accepted for review at the Supreme Court level, went to briefing, and the Supreme Court did a summary decision of that case, saying that the case was moot, which I'll explain probably sometime during the course of the debate. I've actually litigated the very section of the Constitution in question, one of the few lawyers in America who can do that. The rest of you from Virginia probably know that I was a Republican nominee for Lieutenant Governor of Virginia in 1993. I've been a faithful member of this party for a long, long time and have helped elect a lot of Republicans here in Virginia, and I'm proud to be a member of this party here in Virginia. Let's start off with this proposition. A lot of us think, and I'm sure Mr. Fry agrees with this statement, that the Constitution is not being obeyed by the government. The federal government just simply ignores the Constitution if we define the Constitution correctly. And defining the Constitution correctly is this: the Constitution as written and intended by the founders. That's the correct understanding of the Constitution. Now, however, there's a second Constitution, a de facto Constitution, and that is the Constitution as interpreted by the Supreme Court of the United States. The reality is the government does follow the Constitution, just the wrong one. It follows the Constitution as interpreted by the Supreme Court of the United States. And I can't think of a single material part of what makes the Constitution great that has not been changed by the de facto practice of the Supreme Court of the United States. I can't think of anything, whether it's separation of powers, limited government, enumerated powers, the rights of the people, that we won't spy on our own citizens, that the president doesn't have legislative authority, that the judiciary doesn't have legislative authority, that the bureaucracy doesn't have legislative authority, that we're not going to follow international law, we're going to follow the domestic law of the United States, where Americans make the law for America. I can't think of a single major premise in the Constitution that makes it great, that is actually being enforced by, and in practice, by the current federal government. Washington, D.C. is drunk with power, and I contend that Washington, D.C. will never correct it itself. So the question is there another correction? I advocate using the correction that is in the Constitution itself, and that's Article V. Article V was given to us by a Virginian who didn't live very far from this spot right here, George Mason. George Mason is the person who said at the end of the Constitutional Convention, look at guys, this government's going to run away with power someday. And when it runs away with power, we have to have an ability for the states to be able to correct the abuses of power by the federal government. And if we follow the system that we're following, where Congress proposes all amendments and the states ratify amendments, we'll never have a proposal given to us for ratification from Congress. Congress will never propose an amendment to restrict or limit its own power. And that's the reality. Since the Bill of Rights, since the founding generation, if we can start, the 11th Amendment, I guess we can count, but past the 11th Amendment, Congress has never proposed an amendment that restricts the power of Congress, ever. And if we think it's going to do so in this day and age, we are absolutely deluding ourselves. So our options are very few. Our options are to use the Constitution. Our options are to be wishing and hoping that we're going to elect new people to Washington, D.C. that are going to do better than the last people we elected to Washington, D.C. And if we really get enough of our kind of people in Washington, D.C., they won't get drunk with power, they won't get Potomac fever, we're going to have a supermajority there in Washington, D.C., and they're going to structurally change Washington, D.C. We can do wishing and hoping, thinking and praying all we want, and I don't care how many times Dusty Springfield sings it. It ain't going to happen, ladies and gentlemen. It just ain't going to happen. Or we can engage in basically an armed revolution. That's our alternative. Armed revolution is not something that as a Christian you can ever advocate when you have a lawful place in the Constitution right now to do what we need to do. Article V gives us a lawful alternative, and any form of armed revolution, which includes nullification theories that basically say the state leaders need to pick up their guns and shoot the federal officials. That's a form of armed revolution. And that's the position advocated by my opponent today in the debates that he's done before. I've never debated him before, but I've looked at his materials online. That kind of nonsense, that kind of anti-government activity has no place in the Republican Party, has no place being followed by Republican delegates in the General Assembly. Yet, ladies and gentlemen, some of them unfortunately are. Just imagine, what would the government be like if the president never, in the whole history of the country, never vetoed any bill of Congress? Do you think there'd be abuse of legislative authority? Absolutely. What if the practice was, for 200 plus years, that the U.S. Senate always approved every single measure that came from the House of Representatives? What would it be like? It'd be a mess. What would it be like if the states never used their constitutional authority to trump the power that, well, they never have? And what we're experiencing today is the federalism atrophy that comes from the states never using their constitutional authority under Article V to restrict the power of the federal government. We see a runaway federal government that's absolutely drunk with power because the states will not, have not, and are being fear-mongered against using the actual Constitution itself. Now, we have a handout here. You've been told the lie that the Constitution itself was a result of a runaway convention. You need to stop getting your history from the Common Core. You need to stop getting your history from secondary sources. You need to go and read the original documents. Virginia called the Constitutional Convention, not Congress. Congress is the one that said, we're going to have a convention only amend the Articles of Confederation. Virginia called the convention, instructed its delegates, and Virginia said, render the federal Constitution adequate for the exigencies of the Union. Those were the instructions to the constitutional delegates from Virginia, and they did exactly what they were told. 10 other states, 10 total states, followed that format exactly. 2 states did something slightly different, but the majority, the strong majority, the supermajority, followed the Virginia example. That's what the Constitutional Convention was called for. It was lawful, it was done properly, and people who claim to be constitutionalists yet say the Constitution was illegally adopted. It's like saying, you know, George Washington was a great American patriot, but you know what? He was also a British spy. You know, pick your sides. Either the Constitution was lawfully adopted, properly adopted, or it's not. I stand for the Constitution.
Thank you all, and good morning. I'm happy that you're here, and I'm happy to be here. I appreciate being invited. To start off, let me give a little background on myself. I'm just a humble son of a carpenter. I'm not a millionaire. A lot of the people that are promoting this are millionaires. In fact, the main promoters of this are billionaires. I do not make hundreds of thousands of dollars. Most of the people that are being paid to go out and promote this thing are making hundreds of thousands of dollars. The reason that I do this is my concern for liberty and basically for my family. You know, I sat on my butt for 47 years and I didn't care about politics and all that nonsense. And then I realized that we had a serious problem with our government. Something had to be done, and I started getting active. And because, you know, we deserve what we get, right, when we sit on our butts. And I do deserve what we get. And some of you probably feel the same way, that you've sat on your butt a little bit too much and you deserve what you get. but I have a son that has nothing to do with this and doesn't deserve any of it, right? And I'm not going to stand in front of my maker and tell him I squandered my son's liberty. So that's one of the reasons I'm here. Now, I'm not a, I've done civil litigation for about 20 years. The biggest case I worked on was $350 million. I didn't do a lot of nickel and dime, trip and fall cases, okay? But let me tell you something, and I tell everybody this in my presentations. We have 200 years of case law from the Supreme Court that says the Constitution was written for the average person. If somebody tells you you have to be an attorney or a law professor or a judge to understand the Constitution, they're blowing smoke, okay? You don't have to be that. It was written for you guys so you could understand it. And I've been fighting Article 9 since about 2009, trying to mostly educate people and get them squared away on what all the facts are. You need to answer one simple question to decide whether or not an Article 5 is proper. All the rest of it is basically irrelevant. You know, you need to answer this question for yourself. And the question is, why should we believe our public servants who have been violating the Constitution and their sacred oath for over 100 years suddenly start honoring the Constitution if we change the structure of the Constitution? Patrick Henry said, "It is natural to man to indulge in the illusions of hope. We are apt to shut our eyes against the painful truth and listen to the song of that siren till she transforms us into a beast. Is that the part of wise men engaged in a great and arduous struggle for liberty? Are we disposed to be of the numbers of those who have eyes, see not, and having ears, hear not, the things which so nearly concern their temporal salvation?" Pardon me. For my part, whatever anguish of spirit it may cost, I am willing to know the whole truth, to know the worst, and to provide for it. If our public servants won't uphold their Constitution, why is rewriting the Constitution the solution? Patrick Henry also said, "I know of no way of judging the future but by the past." Our past experience is, for the last 80 years or so, the federal government, the officers in the federal government, have not been upholding their solemn sacred oath. They put up their hand and took an oath to God to protect and defend that Constitution, and they're not doing it. Our public servants, many of them, have no fear of God and have no fear of the people. If we will not obey the Ten Commandments, why should we rewrite those? Is that going to work? Are we going to turn sinners into saints? If your spouse cheats on you, would you consider rewriting your marriage vows? It's the same thing. Of course not. It defies logic, and it's contrary to human experience. And let me say something real quickly here about this myth of the two constitutions. There's only one Constitution. And that Constitution is the one that the founders made. When they say that they're going to modify that Supreme Court, that myth Constitution, it's not going to be that myth Supreme Court Constitution they're changing the words on. It's going to be this one, the one that's in the National Archives, the founders. And let me concede these quick points for this to prove my point. If they get their way, let's assume that the Article 5 promoter is going to get their way. So whatever rules apply, they say will apply, will apply. If they say the states control, the states control. If they say that the states pick the delegates, the states pick the delegates, okay? In fact, what I'll concede is that the delegates are all going to be angels, and they're also going to be conservative angels, and if you like, they're going to be GOP conservative angels. The conference itself is going to be headed and chaired by the Archangel Michael. They're going to get every amendment they want. They're going to get it in the exact language they want. They get it ratified quicker than any of them have ever been ratified. And when they deliver that Constitution to Congress and the President, maybe someone like Obama, it's going to have a holy glow about it. So now, again, ask yourself, why should you believe that these guys are going to honor a Constitution a new constitution when they've been violating their oath for almost 80 years. It's just beyond belief. A new constitution will not turn corrupt politicians into statesmen. And the Constitution itself is not the problem, and I think they concede that. Changing it is not going to be the solution. They want a structural change for a personnel problem. And the root problem is, and I'm here, it's like Patriot, I'm here to tell you the painful truth. I'm not here to sell you something and be slick about it. The painful truth is, we're the fault. We the people are the fault, because our job, morally and patriotically, under the Constitution, as set up by the founders, was to hold our public officials accountable. In this country, we're the sovereigns, we're the kings. They're our servants. When our servants get out of line and we don't correct them, just like our children, then we are responsible. So we are the problem, and that's what needs to change. Until we fulfill our moral and patriotic duty to hold our servants accountable, no change to the Constitution will matter. And once we hold them accountable, no change to the Constitution will be necessary. We have they want to tell us that we really have no responsibility for this problem, right? It's the same story. It's a status quo in a different package. Don't worry about it. It's not your fault. It's those lying politicians. It's all their fault. And by the way, don't worry about it. You're not going to have to change anything or get involved to change this. You just kind of support us, and we're going to get the states together, and they're going to fix everything. Everything's going to be okay. Well, a big problem with that is that the states have been complicit with the federal government for 80 years in undermining our liberties. They take federal money that the federal government does not have constitutional authority to offer. The states do not have constitutional authority to accept it. So how's that going to change? They're being bribed. Most states rely upon federal dollars for their budget. Mostly 30 to 50% of their budget is federal dollars. So a real serious problem. The other thing we need to understand is the history of this. The Article V movement started about 50 years ago when the Ford Foundation spent about $500 million to $1 billion in today's dollars to fund the creation of a new constitution and get the Article V going. And the Rockefeller Foundation was also involved during that period of time. And so we're seeing a continuation of the Billionaires Boys Club promoting this kind of a situation. And these are some of the same people that promoted and got the Federal Reserve Act passed. Some of the organizations that are involved in this, all right, I'll stop there. But again, you have to ask yourself, why are our politicians going to follow a constitution when they haven't followed the one that they have?
Thank you, Mr. Farris and Mr. Fry. The next phase of this debate will be questions, starting with Mr. Farris to Mr. Fry. It'll be a 1-minute question followed by a 2-minute answer, and then we'll alternate back and forth for a total of 6 questions. If you arrived late, please silence your phones, and we'll move on with the next phase. Again, 1-minute question, 2-minute answer, and then I would like you to segment your answer before the next question begins so we can keep the timing straight. So, Mr. Farris.
Mr. Fry, I have a 2-part question. The basic question is, what do you propose that we do to stop the runaway federal government in Washington, D.C.? Number two, an aspect of that, have you advocated and do you advocate that state officials take violent action against federal officials to be able to implement nullification?
Okay, I'm sorry, what was the first part?
What do you propose that we do to solve the problem of an abusive runaway federal government in Washington, D.C.?
Well, you know, this is a common diversionary tactic that the Article V people use. The premise here of the question is that if I don't have a solution, then somehow their solution's okay, I can't challenge it. You know, it's like being in a ship that's taking on water and the captain comes down and says, hey guys, we need to drill holes in the bottom of the ship to let the water out. I come along and say, you know, I don't think we ought to do that because that might make our situation worse. And they're saying, well, do you have a better solution? If not, just be quiet. We do have a solution, and if you want to attend a seminar or us talk about it sometime, we'll spend 2 or 3 hours to talk about it. But very, very briefly, what it amounts to is the founders set up a system where the states, working with the other states and the citizens, were to keep the federal government in check. Okay? And you're not going to do that with an Article V. Paper will not confine, restrict, or slow down corrupt politicians. You got to do more. I'm sorry, what was it?
Have you advocated, or do you advocate that states use violence, use armed authority to challenge the federal government?
No, we do not. However, I do tell you this. The states are required, again, not to follow unconstitutional enactments of the federal government. We have an automatic nullification provision in the Constitution, Article 6, Section 2. Some call it the Supremacy Clause. If a federal enactment is not consistent with the Constitution, it's not law. That means that someone going out to enforce this does not have authority to do that. They may have color of law, but they don't have the authority. If that's the case, the states do have the ability, in fact they have the duty, absolute duty under sovereignty, to intervene and say, that's not a proper law, you don't have authority, you need to stop it.
And Mr. Farris, your question.
Yeah, my question is that Professor Nadelson has said that when Congress is acting in a Article V situation, that the Congress is not part of the federal government. Could you explain that for me?
It's not a part of the normal legislative process of the federal government. In fact, that's part of the case that I litigated regarding the Equal Rights Amendment. When Congress proposed the Equal Rights Amendment originally, using 2/3 of both houses of Congress, like Article V specifies, it proposed the Equal Rights Amendment with a 7-year deadline. Then, attempting to use ordinary legislative power, simple majority of both houses of Congress, a law signed by the President, they purported to change the deadline for ratification by adding about 3.5 years. It was June 30th, some particular year. And so they tried to use ordinary legislative power to do that. And the court held that Congress, when it's acting under Article V, only acts under Article V. They cannot use ordinary legislative power to do it. The President has no authority. Congress cannot use simple majorities passing regular laws to do it. It acts under Article V, only under the provisions of Article V. That's what Professor Nadelson meant. That's what I litigated. That's what we won. That's the law. That's what the Constitution says, and that's what the law says. It's a rare occurrence where the courts actually got it right. That's, like a broken clock, it gets it right once in a while. But that was one where they got it correct. I guess that's my question. Now, I'm going to just follow up on the last one. Let's take the federal debt. How are the states supposed to nullify the federal debt? And I'll give you a compound question here. Let's take federal firearms regulations, which I think were totally unconstitutional.
And you're right.
Yeah. So a federal firearms agent comes in and arrests a Virginia citizen, and a Virginia sheriff thinks that law is unconstitutional, and the Virginia citizen's being hauled away by the BTAF employee, and they're being taken to federal jail, and they're being prosecuted in federal court. What are the Virginia officials supposed to do to nullify that abuse of federal power?
Well, again, to begin with, there isn't such a thing as state nullification. There's constitutional nullification, and that's why there's not state nullification, because a federal enactment that is not consistent with the Constitution, we've got 200 years of Supreme Court cases, pardon me, it never becomes law. Therefore, the federal government agents do not have authority under the law, because there is no law, to enforce those. So, obviously, what the states need to do is to step in there and say, look, if we're not going to let you arrest our citizen under an unconstitutional enactment and bring it to a head. That's part of their duty as a sovereign. under allegiance and protection. That's part of their duty, to interpose, to step in the way. They're not nullifying anything. They're upholding their duty, number one, under the Constitution, because every state officer takes an oath under the federal Constitution to support the federal Constitution, and it's an active duty. It's not a passive duty. It's not just to refrain from violating the Constitution. It's to protect the Constitution aggressively and actively. So they do have that responsibility, and the fact that they don't do it, it is part of the problem that we have. That's a check that we don't have. And simply changing the Constitution isn't going to change that on the part of the state officers. The text of the Constitution grants the convention, not the state legislators, the power for proposing amendments. The framers could have drafted it otherwise, but they chose not to do that. And my question then is, when there are proposals for the state legislatures, either through compacts or through delegate selection provisions, which Kansas has passed, which is the governor and the head of the House, head of the Senate, the ability to not only appoint delegates, but to absolutely control what they say, even requiring them to call back to the governor to ask permission to vote on something in the convention. Doesn't that interfere with the deliberative process and requirement under the Constitution for the convention to be independent and operate as a deliberative body versus a puppeteer of the governor?
Okay. Well, it's a great question. And there's two components. There's a political component to it, a wisdom component, and there's a constitutional component. The wisdom component is it a good idea to so tightly control the delegates that they have to call into the governor for every particular vote? I would say that's an unwise approach. But the question is, the constitutional question is, do the state legislatures have the power to tell the delegates, give the delegates instructions that are binding upon the delegates? The answer is yes, they do. Here's the example. And we know it. It's a very important one. The Delaware delegates to the United States Constitutional Convention were instructed to not vote for a plan that didn't give the states equal representation. And it was the state legislature in Delaware, from Delaware, that told the Delaware delegates, and the Delaware delegates stuck to their instructions, is the reason we have the Connecticut Compromise and the U.S. Constitution was bifurcated, with the House being on population and the Senate being equal representation between the states. Delaware was the first state to ratify the Constitution, showing the Delaware delegates faithfully executed their instructions. I think the instructions given by the states should be general, but the instruction of the states that they're directing their delegates to only debate the issues that are in question, which our application, which has been passed by 3 states, Georgia, Florida, and Alaska, says we're going to impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, and impose term limits on federal officials. Those instructions to the delegates to stick to those topics is not only wise, it's constitutionally enforceable, and it will result in the results we want. Okay, my question. Okay, I'm back to my question. I'm back to my my scenario here, because I just want to play out. I think you do have a responsibility to propose a solution. And so my question is, okay, the state government decided it is going to deliver this this guy who got arrested by the VTAF, and he's standing in front of the federal judge, he's being held by federal marshals. Isn't it going to lead to armed conflict if the states try to rescue that person from the federal court system?
Well, I don't, the states shouldn't allow themselves to get in that scenario, for one thing. They shouldn't allow that to happen. And their approach really should be at that point, and that's a sovereign decision for them to make, but to try to address it through the court system, to go directly to the Supreme Court. That's the court that handles that, which is another problem that we have. A lot of these attorney generals will either respond to federal lawsuits in the federal district court, or they will file lawsuits in federal district court. The federal district court don't have any authority over the states. Under the Constitution, it's simply the Supreme Court that does, and they need to start going to the Supreme Court. Don't Mickey Mouse around with the lower courts who have no authority. And as the founder said, for the states to go to an inferior federal court is beneath their dignity, because they're sovereign. They're sovereign, just like if they were England or another sovereign country. And that's the way they need to be treated.
Yeah, Mr. Fry, it's your question, and this is the last question.
My question is this. The Supreme Court has held, and I believe this is a correct holding, that the actions under Article V are federal functions. So even when the states are ratifying an amendment, that is not a state action. It doesn't come from state authority. It's a federal function that comes from the Constitution itself. So my question, though, is based upon that, how do you explain all this additional authority that the states have to direct, control, and manipulate the convention when in fact it's a federal function controlled by Article V, and there's no authority in Article V for the states to do that?
Is my microphone gone off?
Do you want to step over here?
Thank you. Appreciate that. When the states are acting under Article V, they're acting under direct authority of the Constitution of the United States. There's a difference between federal constitutional authority, federal statutory authority, federal regulatory authority. There are kinds of federal authority. They're not acting under the law of Congress. They're acting under the power of Article V itself. Congress is granted power and limited power by Article V. The states are granted power and limited power. If you want to say it more succinctly, the states are exercising constitutional authority, not statutory authority. They're not getting their power from the state constitution. They're not getting their power from the state laws. They're getting their power from their state authority. This is a wholly devoted subject to the state legislatures. The legislatures get to name their delegates. The legislatures get to decide what the applications are going to be for. We have over 400 applications right now pending in this country for an Article V convention. The reason we've never had one is the states have not agreed on a topic. So we have an absolute understanding from 200 plus years of history that when the states agree on the topic, then and only then is a convention called. And so we're trying to get the states to agree on the topic. Let's limit the power of Washington, D.C. We've done it on abortion, we've done it on voting rights, we've done it on lots of other things we've tried to do it on. But we're trying to say, let's limit the power of Washington, D.C. in fiscal, jurisdictional, and tournament areas. And when 34 states agree to that, using their Article V power, their direct constitutional power, they're not subject, they're not under Congress, they're not under the President, they're not under the Supreme Court, they're not under anybody. It's a direct grant of authority from the Constitution itself, and that's no form of inferior power. The Constitution is the supreme law of the land, but the supreme political power in the land rests with the states, because the states, and only the states, can unilaterally amend the Constitution. Wouldn't you rather have the General Welfare Clause? I'll say it later. I'm going to
Okay, Mr. Roach, say let's go.
Hello, it's back on.
Back
Okay.
in business. So we're going to have both the debaters stand by the mic that just works again. If you have a question, I'd like you to come down and sit in these seats. We're going to have time for 5 or 6 questions. You guys will just be over there. We'll use this one. You know what? You have notes here, so we'll just have someone step up and you'll stay. I think you have notes too. But we'll just use this mic for the questioners.
Actually, I'm not really using notes, so they can use.
So again, a reminder, the question should be a question. It should be brief. 30 seconds is the maximum. Doesn't mean you have to use all 30 seconds. We don't want a monologue. We want to hear from the debaters, not from the questioners. So I see we have 5 questions right now. Ma'am, if you'd come up with your first question, use this mic, please. And then we'll have 2-minute response from each candidate, Mr. Farris and Mr. Fry.
My question is 2-part. 1, who would choose the delegates when we couldn't trust Mr. McAuliffe, sorry, I call him McAuliffe all the time, so I get mixed up.
Just say the current unpleasantness.
And since the Supreme Court has overruled, and in many cases uses their case law to determine state rights, how would this that you're offering override and force them to go back to a constitution as we see it as written? Thank you.
The answer to your first question is the state legislature, and only the state legislature picks the delegates. The governor has no authority whatsoever under Article V. He doesn't have to sign the application or the resolution that's passed. He has no authority. So the current unpleasantness is not an issue in this state or any state. Currently, there are 31 states where the Republicans control both houses, and some people say, well, how can we trust the Republicans? They're not that good on this. I'm more favorable to the Republicans than those comments, but I don't think they're angels. But here's the point. Who's more conservative on this issue? How much power should Washington, D.C. have? Republican state legislators or members of Congress? Those are your active choices. And Republican state legislators are conservative on the question of who should have more power, state legislatures or Congress. On that issue, we're trustworthy. The question you have is a derivative, about the Supreme Court, is a derivative of this big question. How can we trust the officials to obey the Constitution if we amend it compared to the one that we have in place now? Well, first of all, we're not going to leave the Supreme Court in the position that it's in. The Supreme Court has said 30 times there is no realistic check on our power other than our own internal sense of self-restraint. That is not going to be the case. Mark Levin has proposed some amendments to how we give checks and balances on the court. I propose that the states appoint the Supreme Court justices for limited terms. I propose that federal lower courts be for limited terms, and I also advocate that the federal district courts be appointed by the states. When we have real checks and balances on the courts, the game changes. But I have effectively overruled the Supreme Court. I wasn't the only one, but I was a part of a team. I'm the guy who named the Religious Freedom Restoration Act. I was the chairman of the group who wrote it, and I'm out of time. I'll expand later.
Can you believe that you have attorneys that are actually trying to obey these rules? That's amazing. The first part of your question is this. First, let's assume that the states select the delegates. Then my question is, so the states select the delegates and they do this amendment thing, and then they get it to Congress. Why is Congress going to follow it? It hasn't followed it for 100 years. That's number one. That's why the rest of it doesn't matter. That's why delegate selection doesn't matter. Number two, I would encourage you to read Article V, because you'll find that it doesn't grant the states authority in that regard. And if you look at the Article 1, Section 8, Clause 18, under the necessary and proper clause, the Congress has a right to do laws that are related to the duties that they have. And one of their duties is to call the convention. So under that, they would have authority that the states do not. Oh, I'm sorry, what was the second part of the question?
You answered.
Good morning. Just to identify myself, I'm Jim Maloney, member of the House of Delegates from the 67th District, and welcome to the 67th District. We've heard a couple of comments, including just in I think the most recent response, that federal officials don't follow the Constitution, so why amend it anyway? Last I checked, we still have congressional elections every 2 years. The people who we defeated last month really are moving out of their offices on Capitol Hill. The people are coming. The Electoral College meets every 4 after a presidential election. We still raise money for a national defense. It seems that where the Constitution is specific, it is being followed. I'd be happy to hear otherwise if you think that's not true. Where we've gotten off course is where the Constitution is less specific and therefore open to years and years and years of the accumulation of court opinions. So my question is, if a convention were to meet and draft amendments that are specific, why wouldn't they be followed?
Yeah, you're right, but I think we're not trusting that much. Just a little over.
Until it gets changed. Jim, I think that they would. Let's take the General Welfare Clause, for example. The original meaning of the General Welfare Clause is this. If If the states can spend money on it, the federal government can't. Now, if we rewrote the general welfare clause to say that exactly, if the states can spend money on it, the federal government is jurisdictionally precluded from spending money on the same topic, which would mean no more education spending, no more welfare spending, all the entitlement spending that is bankrupting this country would be precluded from federal spending. The Commerce Clause. The Commerce Clause was intended to regulate shipping between the states, not all economic activity. And if we just simply say the Commerce Clause power is limited to shipping, not economic activity, then we've got a very straightforward, simple, clear amendment that clarifies the original meaning of the Constitution, returns us back to limited federal legislative authority. And it will be obeyed, especially when you put in provisions where we have realistic checks and balances on the court. The politics that I've been involved with for 40, I have not been sitting on my butt for 40 years. I have been active for 40 years in these very battles. And so we've been focused on two things: good policy, good people. We got to keep doing those two things. I've done that, and I will keep doing that. But we got to focus on good structure. The founders believed that good structure was important. Checks and balances are important. Federalism is important. We have lost all the structure. Why? Because we have not been insisting on structural changes. Where there are structural problems, structural changes are warranted. When the federal government thinks it can regulate the wages and hours of babysitters, and the Supreme Court says that it can, it's time for structural changes, and we can give it to them through Article 5.
My response would be this. I think that you are very much mistaken if you believe that the federal government follows more specific portions of the Constitution. There is no piece of our Constitution clearer than the Second Amendment. Thou shalt not infringe. And they have been infringing on our Second Amendment rights, or the rights referred to in our Second Amendment, since 1926. And it's getting worse every day. So they don't. We have 200 years of case law that says that the Constitution was written for the average voter, for you guys, for all of us. So it is clear. The Commerce Clause is clear. It's not because they don't understand it. It's because they don't want to follow it. Well, if they're like willful little children and won't follow the Constitution, I don't care how much you clarify it, they're still not going to follow it. Again, if you don't have your politicians under control, if they're not upholding their oath of office, no changes that you make are going to matter. Once you get them under control, you won't need to make changes.
Thank you. This question is directed to Mr. Fry. Do you believe that the second method to change the Constitution in Article 5, that part being debated today, and that part that was inserted in the Constitution at the insistence of Virginia and George Mason, was put in the Constitution by mistake? And do you see any circumstance where it's a legitimate tool of the states?
Well, I do believe that Article 5 is absolutely legitimate. And there's been, sometimes the promoters in Article 5 say that we say it's not. Well, it absolutely is. The problem is, it's not the right tool for the solution. If you just have a hammer, then everything looks like an L, and it just doesn't always fit. You can't really scrape paint with a hammer. And that's kind of what's going on. It wasn't meant, Article 5 wasn't meant to constrain the federal government. It was meant to correct errors. Mason didn't have anything to do with the article that was put in there. Mason's proposals were shot down. This is a Madison proposal. It wasn't put in there by accident, but it's not appropriate for this situation, because the situation is absolutely not a structural problem that needs to be adjusted. It's like Jefferson said, the problem with the Supreme Court was that the Congress didn't use its powers of impeachment enough. They're not doing their job. So changing the Constitution doesn't matter. If that would work, the only amendment we would need to the Constitution is one. It would say, you must follow the Constitution, and we mean it this time. I don't think that'll work.
First of all, I'd note that he didn't answer your question. And that is, under what circumstances would it be justified to use Article 5? When I debated Phyllis Schlafly's son, Andy, who's a lawyer in New Jersey, he said, well, when martial law was imposed then we should use it. I said, Andy, good grief. When martial law is imposed, there's only one correct response. Get your guns, boys. Let's take our country back. I debated the John Birch Society in Oklahoma City, and I said, guys, when you figure out that nullification ain't going to work, isn't going to produce any kind of, we're not going to get rid of the national debt that way and all this other stuff, when you realized that, will you help us with Article 5? He said no. At that point in time, the answer is secession. The people that want to destroy this country deliberately should not be listened to. And that's what the John Birch Society wants. And if Andy's willing, I don't think Andy wants to destroy the country, but if he's willing to say we don't use our power until the country's already being destroyed with martial law, I say Andy's got the wrong trigger for when we use the Constitution itself. And Mr. Fry, I just hate to tell you this, you just don't know what you're talking about relative to George Mason and James Madison and so on. You need to read the actual debates of the Constitution, read the minutes of the Constitutional Convention. It is George Mason that made the motion. It was George Mason that said the federal government is going to disobey its authority. It's one of the reasons he didn't sign the Constitution. One of the reasons he was an anti-federalist and opposed ratification. But he succeeded in putting in the methodology of Article 5 that we have now. When I debated the John Birch Society, they proposed that if they had to have an amendment, one idea would be to require juries in civil trials like we have in criminal trials. I pulled out the 7th Amendment and read it to them. You have juries in civil trials if it's a matter of over $20. It's not enough to sort of know this stuff. If you're going to advocate that you are a leader and people should listen to you, you should know what you're talking about. And if you say that James Madison, rather than George Mason, is responsible for this piece of the Constitution, you've just revealed you have no idea what you're talking about.
My question is predominantly directed at Mr. Fry. So you said that it is the job of the states, under their state sovereignty, to fight back in some way against federal powers that are overstepping the Constitution. And you specifically mentioned Article 6, unless I'm mistaken. Two parts of my question. First, can you explain how Article 6 does that? I've just read it and I don't see it, so can you explain that to me? And second, wouldn't an Article 5 Convention of the States be part of a state response to federal authority?
And what was the first part of your question? I'm sorry, just like.
Can you explain how Article 6...
Oh, okay, I'm sorry, yeah. The way that works is there are two provisions in Article 6 that cause this to come about. And that is that the second, what I call the nullification, others may call the supremacy clause, again, is an automatic nullification clause. If Congress attempts to enact a bill that is not consistent with the Constitution, the Supreme Court has said for over 200 years that it never comes into effect, as if it was never even passed. It's null and void. States don't nullify anything. The other part that triggers it, and there's really another aspect, but the other part that triggers it under the Constitution is the fact that Article 6, Section 3, requires every officer of the state government, judicial, legislative, and executive, to take an oath to support the Constitution. Under that, they have an active duty to protect and preserve that Constitution. That means they can't propose, vote for, sponsor, enforce, or otherwise push along an unconstitutional enactment, because they don't become law. So that's their responsibility. The responsibility also comes from the fact of their sovereignty under allegiance and protection. They have a responsibility to protect the citizens from infringement of their rights. And I'm sorry, what was the second?
Wouldn't a Article 5 Convention of the States be part of that same power?
Well, some consider that such as that. In our current situation, that's not going to work because the federal government, the agents of the federal government, the officers of the federal government aren't following the Constitution. So if you try to amend it and hand it to them, what makes any of you, I mean, does anybody really believe that they're going to follow it now all of a sudden? So it's just not appropriate. It doesn't work. I'm not saying it's not constitutional, obviously it is. It just would not be effective in this situation.
Let me just see if this is back on. They changed the microphone. Okay. Earlier, Mr. Fry said when the states are trying to nullify, they should go straight to the Supreme Court. Huh? If they're not following the Constitution anyway, the solution is for the states to go straight to the Supreme Court. I say the solution is we curb the power of the Supreme Court. If we don't have realistic checks and powers on the Supreme Court, we will not have them obeying the Constitution of the United States. That's the plain reality. And we have to have effective checks on the court. There are ways to do it. There are a variety of ways to do it. And, you know, Levin's proposed some, I proposed some, other people have proposed some. But we've got to find some realistic checks and balances on the Supreme Court of the United States, or our country is going to be ruled by this 9 old people appointed for life, as my law professor once said. You know, that's what's, it used to be 9 old men appointed for life, it's now 9 old people appointed for life. But we've got a real problem. Now, how do you get the Supreme Court to do the right thing? Can changing the law get them to do the right thing? I've done it. In 1990, the Employment Division versus Smith, the Supreme Court of the United States said that you no longer can get a religious exemption from a neutral law of general applicability. Meaning, if the state tells Patrick Henry College that we have to hire homosexual professors, we raise a religious argument, or First Amendment argument for that. The Supreme Court said in 1990, you lose, Patrick Henry College. Now, the Religious Freedom Restoration Act changed that. And we reinstated the former law and bound the Supreme Court. When Hobby Lobby won its case this last term, it didn't use the First Amendment as it should have been able to use. It used the Religious Freedom Restoration Act. That I was the chairman of the group that wrote it. I was the guy who personally named the law. And if you don't think that we know how to reverse the Supreme Court, I've done it. You know, I was leader, I didn't do it by myself, but I helped do it. And it can be done if you know what you're doing, you know the law, you know the Constitution, and you know how to constrain the Supreme Court. We can do this.
We have time for about 2 more questions. Once again, no compound questions, brief questions. If you have 2, I'm going to instruct them just to answer the first.
Do I need to respond to that? I think I'm
sorry.
You were first.
You went first.
My question is very brief. I was actually going to ask the same question as the gentleman in the red shirt asked about the purpose of Article V. But I just wanted to follow up because I think, Mr. Fry, you said that Article V wasn't meant to restrain the federal government. That's what I heard you say. Maybe I misheard you. No. But in the last final Federalist paper, didn't Alexander Hamilton say that was exactly the purpose of Article V? He said something along the lines of, because of Article V, we may safely rely on the state legislatures to resist the encroachments of the national government. I mean, I'm curious as to how you cannot believe that was the purpose of the Article V invention. Thank you.
Well, number one is I think Madison said that the point of the Article V was to correct errors in the Constitution. If the states choose to try to restrain the federal government through an Article V, I suppose that's their prerogative to try to do it. And again, we're not saying that that's unconstitutional, but what we're saying it's not effective. It's not going to be effective. If you change the Constitution, you're not obeying it now. You change it and give it to them. Why are they going to follow it? They're not going to follow it. It's like Jefferson said. The problem with the Supreme Court is that the Congress doesn't use its power of impeachment. Now, Mr. Farris is suggesting that we go to a European model of the Supreme Court. Well, we fought a war not to have to do the European model. And in fact, the Ford Foundation, when they paid $1 billion to have our Constitution rewritten and amended, they were trying to get basically a parliamentary type Constitution put in its place. And they wanted to change the structure of it. I don't want a European model. I don't want it. Look at the nonsense that goes on in Europe, and there's lots of these progressive folks that want us to have a European social democracy. I don't want a European social democracy. I want a constitutional republic like we have. So, the idea is we've got to defend the darn thing. Not to amend it, it's got to be defended.
If you go on Westlaw and Google my name, or do a legal search of my name, and see who's been defending the Constitution of the United States for almost 40 years, you'll find lots and lots of cases. You'll find no cases where Mr. Fry has ever argued a constitutional case in court. So we're talking about defending the Constitution. I've got the track record to prove that I've been doing it for a long the time. I'm the one who's, Bob Dole has personally opposed and criticized me because I led the opposition to kill the UN Convention on the Rights of Persons with Disabilities. Because I happen to believe that Americans should make a law for America. And so I've been doing what he's advocating that we should start doing. We need to use our power as citizens. This isn't going to be done by some powerful group outside. I don't know where these billionaires are. I don't know where these millionaires are. You know, if you want to write me a check for $1 billion, I'll be a billionaire then, and you know, fit your agenda. But the people in this room know me. I am a grassroots activist of long standing, and we can, with grassroots activists across this country, our plan is based entirely upon energizing the grassroots and getting them to go to their state legislators, to convince their state legislators it's time to use the power of Article V in the Constitution to rein in the Constitution. Without the grassroots, we can do nothing. And if we don't understand that, we don't understand anything about politics. Now, how will we get them to obey the Constitution? We'll force them. This European nonsense he's talking about. Because I suggested, here's what I suggested, that the state should appoint the Supreme Court justices. That's my suggestion. And where's the European example? Every state, every country in Europe appoints the justice to the European Court of Human Rights. Just because of that, I want a European model. What have I said? I want the states to appoint the Supreme Court justices. What's the example? Europe appoints judges to the European Court of Human Rights. If you want to accuse me of European socialism based on that one factoid, you don't understand about anything about facts, law, or logic, or fairness.
Hello, gentlemen. If this question has been asked, I apologize. In 2012, at the Republican National Convention, the establishment changed the Standing Committee on Rules, which gave the establishment the opportunity to concentrate and centralize more power at the top of the party, and to shut off opportunities for power in the party to flow from the bottom up. This power grab, initiated by Mr. Ginsburg, was his ramming through a change in the rules of the Republican Party.
Okay, ma'am, this doesn't appear to be a question on topic, so please step away from that. One more, thank you, ma'am. One more question.
What's happening again?
Is that your question? Why will it?
Okay.
So you're using the analogy. Okay, we
All right.
understand. So
Okay,
the
got it.
analogy, what stops that analogy?
All right. A Republican convention is a convention of individuals. This is a convention of states. When you go as a delegate to the Republican National Convention, which I've done several times, been a delegate to the state convention several times, you vote as an individual. At a convention of states, it is, and Mr. Fry is right, this is a meeting of sovereign entities. When sovereign entities meet, I also have a degree in international law, when sovereign entities meet, there's only one way that sovereign entities vote, ever. One state, one vote. One nation, one vote. And so the delegates from Virginia caucus, just like they did in the Constitutional Convention. They caucus, and they cast the votes for Virginia. Virginia votes, not the individuals. You don't take this renegade person from California, this renegade from Vermont, and add them together from one idiot from Connecticut or something. It doesn't work that way. It's one state, one vote. You vote by states. There have been over 30 state conventions, multi-state conventions in the history of America. About 2/3 before the Constitutional Convention, about 1/3 after the Constitutional, more or less. Every single one of them has been one state, one vote. We've never varied from that. We've never had a runaway. We've never had anybody violate the rules. It has been one state, one vote. We have a grand tradition of this. We can trust it because there is an entire difference between a convention of individuals and a political convention, and a convention of states. Even in the UN, which holds conventions of states regularly, they have never violated the rule of one state, one vote, ever. And they call nations states, by the way, at the UN level. And so we can count on the fact that the voting will take place that way. It is not going to happen the way that people fear or describe. The analogy is like, it's not apples and oranges, it's apples and carburetors.
Well, the answer to your question is it can happen, frankly. And I was at that convention and saw what was going on. I was up there as an advisor and a monitor. And it was even worse than what you said in terms of mics being turned off and aisles blocked and on and on. The other thing that is curious is this attitude about one state, one vote. But Professor Nelson himself says, and it's in writing, and I think maybe even in Hollywood, that may be the rule of thumb, but that's not necessarily true. It doesn't have to happen that way. And once a convention gets going, they can change their own rules, and they may change it otherwise. It may be changed to an appropriation. So we don't know that that's the case. But again, what we're doing is we're walking back into the weeds, okay? We're walking into the weeds. It's not really that relevant. Let's say it's one state, one vote. Again, you change the Constitution, you give it to the federal government. Well, why are they going to follow it now? Why are they going to follow it? What difference does it make? The rest of that is not relevant, because in the best situation, they're not going to follow it. If everything goes perfectly, and everybody behaves like good little boys and girls, and then you give it to Congress, they're not going to follow it. So what difference does it make? It only gets worse from there if there are shenanigans. And I'm sure the progressives won't be there, and the people from Hawaii, the legislators from Hawaii that are wanting to do away with the Second Amendment and to constitutionalize Obamacare. We don't have to worry about any of that.
Okay, we'll now have 5 minutes from each speaker. Mr. Farris, is your mic up again?
Yeah, I think it is.
Okay, so 5 minutes from each, and then we'll wrap up, and we'll thank everyone.
I agree with Mr. Fry about, at least at this stage, not getting into the weeds. We need to look at the big picture. Here's the big picture. He's asked me one question: why will they obey the Constitution if we amend it? The big question for him is, what's your solution to run away from federal government if we don't do Article 5? So I'm going to address my big question. I'm going to leave it to him to address his big question. My big question is this: they will obey it because we will make them. Once we have alerted the citizens of this country to have the political power to have enough votes and enough pressure and enough political organization where we have 100 people in 75% of the state legislative districts of this country organized to call their legislators, we have created a massive grassroots operation that will not just be called an Article 5 convention, not just ratify the Article 5 amendments that are proposed, but to stay active on a permanent basis as grassroots activists to make sure when the state government gets the power back over welfare, over education, over all these issues, that we're not going to vote in stupid things like the Common Core. You vote against the Common Core. You vote for tax credits for private schools. You do good things. You don't do bad things. Eternal vigilance is always going to be required, and eternal vigilance is the life I have lived for a long, long time. Anybody that thinks that I advocate, let's just do it and go home, hasn't been paying attention to what I've been doing for about 40 years. This is a job of eternal vigilance where we get the power back to the states, where the citizens have the opportunity. Why? Because the states can be watched better than federal government, and your rights can be protected better. It's about protecting and preserving the rights of the people. The ultimate guarantor of our liberties are the people themselves. When the people can see that they can force structural changes on the federal government, the people will be empowered to come back into politics. Because right now they think it doesn't matter. They think there's no difference between the Republicans and the Democrats. It doesn't matter who we send to Washington, D.C. It's all the same slide into the abyss. If we're going to give them a message that there's an actual difference, we've got to have a plan that says we're going to make a difference. And a plan of defeatism is not the plan of this country. I am not one for defeatism. When I ran for lieutenant governor, I said this at the end of my nomination speech. I believe that America's best days are yet ahead. Now, if we were to look at the time that's passed between 1993 and 2014, it's been a grim walk. But I still believe that America's best days are yet ahead. At the point in time, the American citizens stand up and actively advocate for constitutional methodology that will actually work, will actually change the General Welfare Clause, actually change the Commerce Clause, and will actually change the power of the Supreme Court. If we do those things, this country will go for a political, and I believe, I hope, a spiritual revival as well. That if we unleash the power of the American citizen to no longer be a puppet of the federal government, the states are no longer begging Washington, D.C. for anything. The whole bribery system is gone. The tax money doesn't even go there in the first place. We are going to, one of the things we'll do, this audience will love it. The Beltway will never be jammed again. And so if we are successful, ladies and gentlemen, we can have back our American Republic. Or we can wring our hands, have fanciful ideas about nullification that only lead to one result. I kept asking the question, and he kept avoiding the answer. Realistically, only one thing happens. The state officials have to pull their gun and shoot the federal officials under his theory of nullification. Because a single individual can't determine for himself whether or not the Constitution has been violated. We didn't really like that when Mark Herring decided the Constitution of the United States made our state constitution on marriage illegal. He nullified, just under the theory that Mr. Fry's arguing. The Attorney General of Virginia nullified the Virginia Constitution under the very theory he's talking about. He, as a state official, took an oath to uphold the Constitution of the United States. His reading, his personal reading of the 14th Amendment said the Virginia Marriage Amendment was unconstitutional. That's the kind of power he's talking about. We don't want one person being able to decide for themselves what the Constitution means and make those final decisions for themselves and go to war over that kind of nonsense. We've seen them try it in other areas. But just remember Mark Herring. Whenever you think of the power that he's advocating, keep Mark Herring straight in your mind and avoiding the marriage amendment that we all worked for, that we all helped pass. I don't want that kind of abusive power in the hands of one individual or even one state. When the states act together, 2/3, 26, 3/4 ratified, when the states act together, power can be used safely. God bless you.
Well, Mr. Farris says that the feds are going to obey the Constitution because we're going to make them obey it. Well, if we have the power to make them obey it, let's do that now. Why do we want to change the Constitution and then try to make them obey it? That doesn't make any sense. The other thing is, again, this has been going on for 50 years, right, with the Ford Foundation. You know, every 10 years they come back and there's some new hickey that they put on it to try to get it through. And it reminds me of a few years ago, my son comes up to me and says, Dad, I want to get in the garage to feed the cat. And I said, well, Dean, you know, the cat's out in the backyard. He goes, oh, well, he says, I'd like to get in the garage because I'd like to get my bike. And I said, well, Dean, your bike is out there in the bushes in the front because you failed to put it in the garage last night. Oh, well, I said, well, Dad, I'd like to get in the garage because I want my skateboard. Oh, well, you don't get on the skateboard. I caught you riding in the street with it. You're not allowed to get in there. At some point in time, I understand that he doesn't want to feed the cat, he doesn't want the bike, and he doesn't want the skateboard. He wants in the garage. Now, I don't really know why he wants in the garage. I suspect it had to do with some firecrackers I had in there. But he wanted in the garage. These guys want a convention, and they'll say about anything to get it. They started out and it was just a regular Article V. Well, that didn't work, so then they moved, it's going to be a limited. It's going to be a limited, right? And then it's going to be a conference of states, and it's going to be a convention of states. We've got to ask ourselves, why are they doing it? You need to look at the history of this. You need to look at some of the people behind it. It's been going on for 50 years, and people have spent probably billions, you know, at least $1 billion, but over that in that time trying to promote this. The root problem is we the people. We need to do more. We need to be active. We need to be involved. We've got a moral duty. What is liberty? What is liberty? It's free will. It was given to us by God. It's unalienable. You can't take it away. They're trying to take it away. And we have a responsibility to defend that, and we have a responsibility to make our public servants toe the line. They're not doing it. We're not doing our job. We've got to do our job. When they're doing things that are not allowed by the Constitution, they're committing treason to the Constitution. That's what John Marshall called it. Chief Justice John Marshall called it, and that's true. And we need to treat it as treason to the Constitution. And we need to keep a clear focus of what the problem is. Again, us. We're the solution. And we'll try to get the states to do something before we get them under control, because remember now, they're active in this as well, right? Taking federal money they shouldn't be taking. That's like asking Frank James to watch Jesse James. That's not going to work. We need to get them under control. Changing the Constitution will not change oath breakers into oath keepers. It won't happen. The job is, we need to do our responsibility. This is like, you know, if people are running a stop sign, they're telling you that you can put up a new stop sign and all of a sudden it'll work. It won't work. They're still going to ignore the stop sign. The problem is we need a traffic cop. And unfortunately, or fortunately, we are that traffic cop, right? We need to get off our guff and do what's necessary. And not just handing out literature at election time and voting for the right party. That doesn't get us anywhere. We've been doing that for 80 years, right? We need to be active and make them toe the line. And the beginning of that is we all need to know the Constitution. It's not that complicated. We need to know the principles of sovereignty. And we need to make sure they know it. Hey, what's going on now is we're all sitting around at this poker game, and we see that the dealer's sitting there dealing from the bottom of the deck, right? And these Article 5 people are coming up to us saying, you need to get a new deck. That's not going to change it. The problem's the dealer. Let's get rid of the dealer. I was invited to speak at a Patriot dinner on New Year's Eve, and so I'm driving along. It's a family deal, and I have my family with me. My son leans over the back seat, and he says to me, he said, Dad, do you know what the most popular supper is in the world? I said, Dean, I really don't. He said, dum-dum, Dad. And I sat there and I thought about that for a little while, and I thought, man, that's pretty profound. You know what? Suppers really are the biggest, or dum-dums really are the biggest suppers in the world, right? The one's born every minute. If you don't know your rights and you're not willing to fight for them, you're going to get suckered. You're going to be a dupe and a stooge. And that's what's going on with the American people. And we've got to stop it. And it's in our hands. That's the good news. We don't have to rely upon some political party. We don't have to rely upon a politician. It's in our hands, right? Let's do it like we used to do. Let's show a little faith in God, have courage to do the right thing, right? Not the expedient thing. Like now, the Republicans just took over, right? We're all real happy about that. What are they doing? Leadership now is already compromising, right? Stop compromising.
But if you have time, I'm sure they'll engage you one-on-one. But let's give them all a big round of applause.
How's the marriage?